if the ministry says take down under an advisory a broad category of tweets which talk about a social subject which everyone is discussing, for instance, an armed conflict with a neighboring country or a social problem regarding, let's say, reservations, then that platform will have to come.
Are we to assume that this core purpose will be met or will be applied selectively, as you're suggesting?
So let me put on my policy hat now and not talk like a lawyer.
Just a short while ago, you mentioned the incident of the Election Commission circulating a certain document which had the seal of a political party, the ruling dispensation, that is the Bharatiya Janata Party. I tweeted that article, I tweeted that screenshot, and I got a message from the Kerala police, because it now reports to the Election Commission, that this should be taken down. Hello and welcome. My name is Sanket Upadhyay. You're watching me on TheFederal. The show is called AI with Sanket. This is the AI of news, because news in India today requires not artificial but analytical intelligence. The government has yet again made certain proposals to amend the IT Act, giving itself even more and very many powers in the digital world. We all know that digital media has become the in thing. I won't be wrong if I say that digital media or social media publications, videos, audio clips, commentary has now become mainstream. That is where a bulk of the consumption of news, current affairs, politics, anything for that matter, entertainment, everything is happening, including satire, including commentary, including abuse. All of this is happening on the digital media. The government tried regulation, but now it seems it wants to give itself even more powers in regulating the commentary on social media. Is this just a case of the government trying to sanitize the very nature of digital media, which allows anyone and everyone to come and say whatever they want, sometimes extremely unparliamentary, sometimes abusive, sometimes wrong, where there is a lot of misinformation which can potentially cause a lot of damage? Or is this a case where the government may selectively apply certain yardsticks to take down comments that are unfavorable, videos that are uncomfortable, and then consider its job done? What does the law say? What should we do? And whether we should be really worried about this or not? Is this a case of digital authoritarianism? We discuss. All right, joining us right now is Mr. Apar Gupta. He's a champion of free speech on the internet and how responsibly free speech can be taken forward on the internet. The nature of commentary on the internet, you've seen him actually on various programs, very closely affiliated with the Internet Freedom Foundation and a known speaker on this subject. Thank you very much, Apar Gupta, for joining us. I want to first start by understanding myself, and in that attempt also helping all of us understand what exactly has changed. What has the government proposed?
So I'll start with the basics. There's a law to regulate the internet. It's called the Information Technology Act. There are powers within it which allows the government to require social media platforms to follow certain rules for them being not held liable for the posts which are made by social media users. What this means is that if you post a reel, a post on Instagram, or if you tweet something, then if the platform follows certain rules, it is not liable. Okay. The ministry which looks after this is called the Ministry of Electronics and Information Technology, which is MITE. And these rules are called the Information Technology Rules 2021. These rules are applicable to social media platforms, but also through an expansion in 2021 to independent news publishers such as the Federal, and also online video streaming platforms such as Amazon Prime and Netflix. Now, what the ministry has been doing over a period of time has been amending these rules to increase its censorship powers. People here may remember it amended these rules to insert a fact checking power for itself, in which, if anything was found to be fake, false, or misleading, which are subjective phrases which are not defined, the government by itself could issue an order for its takedown. And this was set aside by the Bombay High Court as unconstitutional. There have been further changes as well, which over the years in notifications which have been there. The notification this year expanded this rule to also apply to synthetically generated information, which in common parlance is AI media, the kind of deep fake kind of concerns which we saw. However, this has been used, as we have seen over the past month, against political satirists, cartoonists, etc. And the most recent proposal was released day before yesterday, which are further expansion of censorial power and surveillance power. What are these changes? Number one, the government can now issue advisories, SOPs, codes of practice, which it does not need to make public and are not understood to be binding within law conventionally, but these will have the character of being mandatory and being implementable by these platforms. So, for instance, if the ministry says take down under an advisory a broad category of tweets which talk about a social subject which everyone is discussing, for instance, an armed conflict with a neighboring country, or a social problem regarding, let's say, reservations, then that platform will have to comply. The second change which they have proposed is that the independent news publishers, such as the Federal or Quinn Scroll, Wire, etc., which were being regulated, will now, those regulations will also apply to any social media user, which means you, me, anyone. Okay, an ordinary social media user who posts on political post their political opinions or comments on current affairs online. What that means is that the Ministry of Information and Broadcasting will also have the power of issuing takedown notices against those specific tweets, reels, but also the entire account itself. And the third noticeable change, which is significant, is that these proposed changes say that under any law, the data of a social media user or any user on any other platform, like even on Google, on Gmail, even, will be retained even beyond 180 days. So what this means is, if you delete your account, the 180-day limit, which was a 3-month limit for the retention of your data, which includes micro bits of data which are gathered by this platform, even what you watch, engage with, right? And how long do you engage, where do you access it, will be kept beyond 180 days, which means it may be required to be kept indefinitely for long periods of time, which increases surveillance as well as the risk of data leaks. So in sum and substance, this is an unconstitutional expansion of executive power over speech as well as our privacy.
Apar, how draconian, if at all, are these new amendments, especially if you compare it with certain laws in other countries? And I'm not talking about a North Korea or a China. I'm talking about democracies.
So, if you look at constitutional democracies, republics which are there, these kind of laws will not be tolerable, because laws need to be passed as per the permission which is given first to the legislative arm of government, at least when it is separation of powers, and then flows down to the executive to make the specific rules which are there. In fact, if you look at the censorial powers which are within it, firstly, just in terms of making non-binding instruments like advisories or codes of practice or clarifications by a government ministry, and not even requiring its publication, binding on social media intermediaries such as platforms, that by itself is legally suspect. And I've not seen that in other countries. Usually in other countries, you have a law, you have a regulation, and the regulation is amended rather than these secret farmans are sent. The second thing, which I think is also very distinct from the other laws on platform regulation, is that the platform regulation is also bundling within itself regulation of independent news media outlets, right? and the censorial power is also being extended. So that's already something which is not there in other countries. And what's worse, this proposal is saying now it will be extended to ordinary social media users. So it does not matter if you are a complete media house, a large media house, or independent news publisher, or a social media user, you're all treated with the same brush. And especially this is incredibly concerning, given that what we have seen in terms of enforcement practices, the government is not saying why it's censoring people who are critical of the government, or even just doing satirical posts mocking the prime minister, and that comes within the scope of freedom of speech and expression. So according to me, these regulations are not fitting any kind of governance purpose. They possibly, on their first read, only satisfy a political interest.
Apar, you must have heard the reasons given for expanding the reach of this law by the government. That there is fake news circulation, that there are attempts to malign the reputation of people in public service, and that must not be allowed to continue. Of course, you cannot have a right to abuse, and also a right to spread wrong information. Now, with the ambit of this new law or the amendment, are we to assume that this core purpose will be met, or will be applied selectively, as you're suggesting?
So let me put on my policy hat now and not talk like a lawyer, and I will comment on certain aspects of our country's political economy. It's perceptible to most people that the people who are spreading misinformation, the people who are engaging in fake news, quite often happen to be associated part of political parties. Every political party officially has an IT cell, which is beyond the regulation of the election commission, unless there is a election itself happening at that point in time. And even then, that speech is quite often not satisfactorily regulated. Second, so there is misinformation which is continuously being spread, and it is being spread with the active support of people who hold some type of power at the state or the center. The second issue is that we have seen widespread online abuse, which is played on tropes which attack our country's diversity, which is religious, linguistic, caste based, regional. And this has been done over a period of time by people who have then politically profited from it. And this is an issue because we see these accounts online and sometimes they are followed by political functionaries, thereby also indicating that they have some form of patronage, and also that's a signal to law enforcement that don't take down their accounts. So why do we have this dichotomy? If the government is actually serious about taking on disinformation, it should invest in independent, autonomous, public broadcast system, which is not existing right now, especially for the digital media. Secondly, it should support journalism rather than being adversarial towards it, offer press conferences, easier access to government, be more transparent in its functioning, thereby encouraging a deeper level of citizen trust. And finally, there are existing laws, Sanket, which are sufficient. We have criminal provisions for prosecution for spreading misinformation, which called panic and disorder. We have the IT rules, which have gone through at least 6 amendments already. You had an amendment this year for SGI rules, which were completely unconstitutional as well. They state that anyone posting inaccurate information will be taken down. And finally, what has been our experience with this kind of power which has been vested with the ministry has been people who have been even posting authentic documents. For instance, the election commission's document, which had a stamp of political party online. There are not only tweets being taken down, some accounts have been restricted. So the practices itself show quite clearly that there is abuse, there lack of safeguards, there's lack of remedy, and this is all being done, again I'll restate, to satisfy the political interests rather than the governance objectives of a government.
Will it stand or withstand the scrutiny of the law, Apar Gupta? Or should it be brought in front of a court of law? Any such amendment?
At present, Sanket, these proposed changes are open to public consultation till April 14th. I would encourage people to go to the website of the Ministry of Electronics and Information Technology, submit their opposition, also talk about it with their friends, family. Quite often that happens through WhatsApp. So do encourage this conversation there, because it's an attack on you, irrespective of the view you hold. If you support government, or you oppose government, or you support a political personality or oppose them, this is a power which is being created. So I would say, even before the courts, there's a active need for our citizenry to engage with this, because today social media, independent news platforms, and the internet are offering a voice which is not quite often heard on the primetime television broadcast or even in the newspapers quite often. So the legality can be assessed by courts at a later point in time, and there has been sufficient commentary now which is also drawing concern on how courts may not be applying the constitution with fidelity, with the understanding of the constitutional precedent which is there for fundamental rights. But I would say we have not yet reached that stage.
Just a short while ago, you mentioned the incident of the election commission circulating a certain document which had the seal of a political party, the ruling dispensation, that is the Bharatiya Janata Party. I tweeted that article, I tweeted that screenshot, and I got a message from the Kerala police, because it now reports to the election commission, that this should be taken down. So
Yes.
I've experienced it firsthand, what you seem to be suggesting. However, my question here is, you must have seen and observed what the government seems to say about your right to abuse. That cannot be a fundamental right. For instance, the manner in which the sarcasm and satirical pieces or skits were performed cannot be a fundamental right. At the same time, you cannot be spreading misinformation, and that too in this AI generation. Ashwini Vaishnav also says that in this day and age of AI, in any case, all over the globe, takedowns have increased. And this is just a part of a sanitation exercise on the internet to make it a safe place. How do you look at this argument?
So, uh, here abuse is actually fairly subjective, because what we have seen is that public officials are seeming to be more thin-skinned than what the law actually permits them. So there are also provisions for criminal defamation in India for public servants which are not existing anywhere in the world. There are legal processes. They need to avail them if indeed that's the case. But I would say, let's think about this a little differently. There's a person who's in elected public office who's drawing money from the public exchequer, for which all of us work, we contribute tax. Even the people who don't contribute tax have a share on it. Okay. And quite often, people will express themselves with anguish, will express themselves with anger. This is a question of their very existence. We don't have clean air. We don't have good water. There's still people who are below the poverty line. There is malnutrition and there's infant mortality. How do people express themselves? I would say this entire argument that people are performing scripts, etc., this is part of a democratic valve in which steam is being let out. If you go even today on the Twitter profiles and accounts of chief ministers and the prime minister, the amount of reach they have, popularity they have is immense. There are people who are fond of them, much beyond them being politicians. And they, in fact, I would say, need to account that this popularity also needs to be taken with a form of toleration towards people who, in a democracy, may at certain points express themselves not with the best language. Constitutional precedent which is there, even when distasteful comments have been done. For instance, I'm reminded of a case when our Prime Minister Indira Gandhi was assassinated, and two Sikh gentlemen at a public chalk had said Raj Karega Khalsa, were prosecuted for hate speech. It was held by the Supreme Court. This did not constitute hate speech. We need to allow people to say these things, not through the prism of legal prosecution and censorship, but public education, toleration. as well as civic awareness, right? We are trying to build an empathetic society. We are not trying to build a carceral society in which people are pushed down and they don't say what they feel. One final thing, Sanket. There's an interesting study in the Policing in India report in 2023 by Lokniti CSDS, and this is a statistic I'm very fond of. They surveyed 10,000 people in 11 states, and they found that two-thirds of online users already do not voice their political and social and religious opinions online for the threat of legal prosecution. So we as a country, rather than being predominantly having a large number of people who engage in online abuse, have a large number of people who are self-censoring themselves and not saying things out of fear.
That's a very important piece of statistic, and thank you for bringing that to everyone's notice, because obviously one realizes that a lot of people are just simply scared. They don't want to get into an uncomfortable situation. We also know how social media companies generally consider it less lucrative to monetize political content or political satire content. All of that is out in the public domain. You say something about entertainment and cricket, and that will do wonders.
Yes.
My Apar, my final question: would you go so far as calling it a sort of a digital censorship emergency of an
You know,
unprecedented kind?
So I'm not fond of the phrase emergency because in the constitution it requires a formal proclamation. An emergency starts under certain conditions and it should end. So I would say this is much worse. I've been writing about it and I've been reasoning it for some years that we are shifting the character of the Indian state from a democratic one, and it's not like we'll become a democracy. We've been on a path from being a post-colonial state to a democracy, but we've now had setbacks in which we are going more towards digital authoritarianism. So that's also present in our first read analysis of these proposed changes. We go clause by clause. We explain why it's impacting people negatively and their rights. And then we state that this is an act of digital authoritarianism. We should not forget only a few months back, the government wanted us to mandatorily install and not have the ability of removing an app which the government would make and would gather our data. And these are steps which are being taken increasingly with respect to our smartphones, and there are justifications which are being given which are not meeting the purpose of satisfaction. For instance, safety of women, disinformation, or online fraud. These are real problems. I completely acknowledge them. But the approach which is being taken always seems to be that the government, the union government, and a specific ministry is empowered. And this should worry all of us.
All right. Thank you very much, Apar. As always, thought-provoking, important, intelligent way of looking at whatever provisions are being brought about. Let's just see what the public discourse results in. Thank you very much, Apar.
Thank you so much for having me. Thank you so much.